There is one form sitting quietly inside many retirement accounts, bank accounts, life insurance policies, and brokerage accounts that can override what your children think they are supposed to inherit. It may not look important. It may be one page. It may have been filled out 20 years ago when your kids were young, when you were still married, when you had a different bank, when your family situation looked completely different. But after you pass away, that form may speak louder than your will. And here is the part most families never understand until it is too late. Your children can have the house cleaned out, the will in hand, the funeral paid for, and everyone may believe they know what mom or dad wanted. But if the beneficiary form says something different, the institution holding the money may follow the form, not the family story. This does not mean you should panic. It does not mean every beneficiary form is wrong. In fact, beneficiary forms can be very useful when they are updated, coordinated, and clearly understood. But when they are outdated, incomplete, or in conflict with the rest of your estate plan, they can accidentally disinherit the very children you meant to protect. In this video, we are going to follow the paper trail. We are going to look at why this one form matters, how it can quietly defeat your will, where families make the mistake, and what you can check before a bank, insurance company, retirement plan, or brokerage firm decides for you. This is especially important if you are over 60, if you have adult children, if you are widowed, divorced, remarried, living with a partner, or if your family has changed since you first opened your accounts. It also matters if you have more than one child and you assume everything will be divided equally. Many people believe their will is the master document. They think, I already wrote down who gets what. My children know what I want. My executor will handle it. That sounds reasonable. But certain assets may not ordinarily pass through your will. Retirement accounts, life insurance policies, payable on death bank accounts, transfer on death brokerage accounts, annuities, and some other accounts may have their own beneficiary designations. That means the institution may look first at the beneficiary form on file, not what you said at Thanksgiving, not what your oldest daughter remembers, not what is written in a note inside your desk, not necessarily what your will says. The system often follows the account record, and that is where the danger begins. The problem is not always that someone made a selfish decision. Many times, the problem is that the form was never reviewed after a major life change. A spouse died, a parent remarried, a child became estranged, a child died before the parent, grandchildren were born, a bank changed systems, an old employer plan was forgotten, a beneficiary was listed by nickname, a trust was created, but the accounts were never updated. And years later, the family discovers that one line on one form controls a large part of the inheritance. Here's the important thing. This video is not telling you to change your beneficiaries today without advice. It is telling you to review what is already on file, compare it with your current wishes, and speak with a qualified estate planning, tax, financial, or benefits professional before making changes. Because changing a beneficiary form can be powerful, but ignoring it can be powerful too. Let's start with the document itself. Imagine a retired father named Robert. This is just an example, but it is the kind of situation many families recognize. Robert has 3 adult children. He has a will that says everything should be divided equally among them. He keeps a copy in a folder labeled Important Papers. His children know about it. His oldest son is named executor. So Robert feels organized. But years earlier, when he opened an investment account, he filled out a beneficiary form naming only one child. At the time, that child lived nearby, helped him with bills, and was the easiest person to list. Robert may have thought, she will know what to do. She will share it with the others. That is the first mistake. A beneficiary form is not the same as a casual instruction. It is not always treated as a suggestion. It may direct the institution to transfer that account to the person named. So after Robert dies, his will says 3 children share everything equally, but the investment account says one child receives that account. Now the family has 2 documents telling 2 different stories, and the institution may not be asking, what did Robert probably mean? It may be asking, who is listed as beneficiary on this account? That is the moment when siblings can go from grieving together to sitting on opposite sides of a dispute. The daughter who is named beneficiary may say, Dad put my name there. The account is mine. The other children may say, Dad's will says equal shares. He trusted you to divide it. And both sides may feel betrayed. But the deeper problem started years earlier, with one form that was never matched to the estate plan. Here is the part most people miss. The danger is not just naming the wrong person. The danger is assuming the beneficiary will do the right thing later. Maybe they will, maybe they will not. Maybe they want to, but taxes, debts, creditor issues, divorce, lawsuits, family pressure, or their own financial situation complicates everything. If you want 3 children to inherit, it is usually better to make the paperwork say that clearly, rather than relying on one child to privately redistribute money after your death. Because once the money is transferred, the legal and tax situation may not be as simple as everyone imagined. Now let's follow the paper trail to the second problem, outdated beneficiaries. This is one of the quietest mistakes in retirement planning because nothing looks wrong while you are alive. You keep getting statements. The account works. The bank does not call you every year and say, "Are you still sure about this person?" Your retirement plan may not warn your children. Your insurance company may not know that your family situation changed. So the old form stays in place. A divorced retiree may still have an ex-spouse listed. A widow may still have a deceased spouse listed. A parent may have one child listed from a time when the other children were minors. A person who remarried may forget that their retirement plan, life insurance, or old work account still reflects the previous marriage. And after death, the family learns that the form did not update itself just because life changed. This is where many seniors accidentally make the problem worse. They update the will but forget the accounts. They meet with an attorney and feel protected. They sign a new will. Maybe they create a trust. Maybe they tell the children, everything is handled. But then the IRA, 401k, life insurance, annuity, or brokerage account still names someone else. That is how a family can have a modern estate plan and an old beneficiary form fighting each other. Pause here and picture the actual paper your family would have to show. Your child walks into the bank. The bank asks for a death certificate and account information. Your child says, "The will says I am supposed to inherit." But the account record shows a payable on death beneficiary. The institution may say, "This account has a named beneficiary." That sentence can change everything. Now, this does not mean every institution handles every account the same way. It does not mean every state treats every situation identically. And it does not mean there are never legal challenges. But it does mean you should not assume your will automatically controls every account you own. That assumption is what gets families hurt. The third part of the paper trail is the missing beneficiary. Sometimes the problem is not the wrong name. It is no name at all. A retirement account or insurance policy may have no valid beneficiary on file. Maybe the form was never completed. Maybe the named person died first. Maybe the percentages do not add up correctly. Maybe the paperwork was rejected and nobody noticed. Maybe the institution changed platforms and the old record was not clear. When there is no valid beneficiary, the account may go according to the plan's default rules, the contract terms, or the estate process. That can create delay. It can increase paperwork. It can push money into probate in some cases. It can create tax complications depending on the type of account. And it can put pressure on the family at the worst possible time. This is especially important with retirement accounts because beneficiaries may have distribution rules after the account owner dies. The timing, tax treatment, and options can depend on the type of account, the beneficiary, and current rules. That is why beneficiary forms are not just inheritance forms. They can also affect taxes, timing, and financial planning after death. Now let's look at the fourth problem. Equal is not always automatic. Many parents say, "I want everything split equally among my children." That is a clear intention. But the paperwork has to match. If you list one child on one account and another child on another account, you may think the amounts are roughly equal. But account values change over time. A life insurance policy may stay the same. A brokerage account may grow. A retirement account may shrink because of withdrawals. A bank account may be used for expenses. A house may increase or decrease in value. So what looked equal 10 years ago may be very unequal today. Here is an example. A mother has 2 children. She names her son beneficiary on a retirement account worth one amount and her daughter beneficiary on a bank account worth another amount. At the time, the 2 amounts are close. Years pass. The retirement account grows. The bank account is used for medical bills, home repairs, and living expenses. When the mother dies, the son receives a much larger amount than the daughter. The will says she loved them equally. The family says she wanted fairness, but the forms created a different result. The paperwork becomes more powerful than the promise. This is why beneficiary reviews should not only ask, who is listed? They should also ask, does the overall plan still create the result I want? The fifth problem is one many blended families face. A senior remarries later in life. They love their new spouse. They also want to protect children from a first marriage. So they say, my spouse can use the money while they are alive, and then whatever is left should go to my children. That sounds simple in conversation, but beneficiary forms may not work that way unless the proper planning is done. If the spouse is named outright as beneficiary on an account, the spouse may receive the account directly. After that, the children may not have the protection the parent assumed they had. The spouse may later change their own beneficiaries. The spouse may remarry. The spouse may spend the money. The spouse may need long-term care. The spouse may have creditors. The spouse may leave the remaining assets to their own children. That does not mean the spouse did anything wrong. It means the original parent may have used a simple form for a complicated family goal. Blended families often need more careful planning than a basic beneficiary line can provide. This is where a qualified estate planning attorney may discuss trusts, account titling, spousal rights, retirement plan rules, tax consequences, and state law. Do not guess here, because the most painful inheritance disputes often happen when the parent was trying to be fair to everyone but left behind documents that could not carry out the full plan. Now let's talk about the form that people forget after creating a trust. A trust can be a powerful estate planning tool when it is properly created and funded. But a trust sitting in a binder does not automatically control every asset. If your account still names an individual beneficiary, or if the account was never coordinated with the trust plan, there may be a conflict between what you think the trust does and what the beneficiary form actually says. Some people say, "I already have a trust, so I do not need to worry about beneficiary forms." That can be a dangerous assumption. A trust and a beneficiary form have to be coordinated carefully. In some cases, naming a trust as beneficiary may make sense. In other cases, it may create tax or administrative consequences that need professional guidance. The point is not to name your trust on everything. The point is to make sure every major account has been reviewed as part of one coordinated plan, because the institution holding the account may not read your mind. It will look at the account documents. Now let's move to the emotional part. When beneficiary forms surprise a family, the damage is not only financial. It can change relationships permanently. A child who receives more may feel accused. A child who receives less may feel rejected. A surviving spouse may feel unsafe. A stepchild may feel erased. An executor may be blamed for something they did not control. And the parent is no longer there to explain what they meant. That is why this topic matters so much for seniors. It is not only about dollars. It is about leaving clarity instead of confusion. One outdated form can make children question a lifetime of love. A 5-minute assumption can become a 5-year family wound. And many times, the parent would be heartbroken to know what happened. The good news is that this is one of the more reviewable problems. You may not be able to control every future tax rule, every market change, every family disagreement, or every court interpretation. But you can ask a simple question today. Who is listed as beneficiary on each account? Not who you think is listed, not who should be listed. Who is actually listed in the institution's records right now? That question can protect your children more than another conversation about your wishes. Here's a calm review process. Start by making a list of every account that may have a beneficiary designation. That may include retirement accounts like IRAs, 401ks, 403bs, pensions with survivor options, annuities, life insurance policies, brokerage accounts with transfer on death designations, bank accounts with payable on death designations, and any old employer plans you may have forgotten. Then contact each institution or log in securely and confirm the beneficiary on file. Do not rely only on memory. Ask for the current beneficiary designation, including primary and contingent beneficiaries. Primary beneficiaries are usually first in line. Contingent beneficiaries may receive the asset if the primary beneficiary has died or cannot receive it. Then check the percentages. If you have 3 children and want equal shares, make sure the percentages reflect that. If one child has died, ask how that affects the distribution. Does that child's share go to their children, to the surviving siblings, or somewhere else? The answer may depend on the wording and the institution's rules. Next, compare the beneficiary forms with your will, trust, and overall estate plan. Do they point in the same direction? Or does one document say one thing while another says something else? Then look for life changes: marriage, divorce, death of a spouse, death of a child, new grandchildren, estrangement, reconciliation, a move to another state, a major account rollover, a new trust, a sale of a home, a change in tax situation, a diagnosis that changes your planning needs. Any of these can be a reason to review beneficiary forms. Then ask a qualified professional the right questions. Do my beneficiary designations match my estate plan? Could any account bypass my will? Are my children protected the way I intend? What happens if one beneficiary dies before me? Should my trust be involved, or would that create problems? Are there tax consequences for naming certain beneficiaries? Are there special rules for my spouse, my retirement plan, or my state? Is my plan fair only on paper, or fair based on current account values? And finally, keep proof. After you update a beneficiary form, save confirmation from the institution. Keep it with your estate documents. Tell your executor or trusted person where the records are kept without necessarily sharing every private detail before you are ready. The goal is not to create family drama while you are alive, The goal is to prevent family drama after you are gone. The one beneficiary form that can disinherit your children is not always one specific government form with one official name. It is the beneficiary designation attached to an account. It may be on a retirement account. It may be on a life insurance policy. It may be on a bank account. It may be on a brokerage account. It may be on an annuity. And if that form is outdated, incomplete, or inconsistent with your estate plan, it may send money somewhere you no longer intend. The central warning is simple. Your family may remember your wishes, but institutions usually follow documents. Your will may say one thing, but a beneficiary form may say another. Your children may expect equal treatment, but account values and old paperwork may create a very different result. This is not about panic. It is about control. You do not need to change everything today. You do not need to guess. You do not need to make emotional decisions. You need to review the forms, compare them with your current wishes, and get qualified guidance before making changes. Because protecting your children is not only about what you own. It is about making sure the paperwork sends your assets where your heart intended. Before this week is over, choose one account and check the beneficiary on file, not from memory, from the actual institution. Then work through the rest of your accounts one by one. And if this made you think of a parent, spouse, sibling, or adult child who handles family paperwork, share this with them. Comment beneficiary if you want a simple checklist of the accounts families should review before it is too late. And remember, before you change a beneficiary form, review it with a qualified professional in your state so one fix does not accidentally create another problem.